Good afternoon and welcome to Roofers Coffee Shop webinar. We are here today at the Northeast Roofing Contractors Association show in Boston, Massachusetts, and we are with Trent Cotney. Today we're going to be talking about contract provision law, and I'm very happy to welcome all of you to this week's webinar. So to get started, first I'd like to introduce Trent. And Trent specializes in roofing law. He is national, has been in the industry since 1999, and I personally have worked with Trent on many groups. He's the general counsel for FRSA, for Women in Roofing, for the RT3, the Tile Institute. Trent's group is truly amazing, and we are just very honored to have him here today to speak to us about contract law. We want all of you to participate with your questions, so please feel free to fill out the box on the left, and in there you will see a place for you to put questions. Our editor, Karen Edwards, is on the line watching behind the scenes, and at the end of this webinar she will take your questions and ask Trent, so you'll have a chance to really get some of the things you're wondering about. I also want to just make sure, and I'll mention this again at the end, but Trent's group does consulting all the time. So after this webinar, if you have questions, all you have to do is call Trent or go online through the coffee shop or on his website and say you saw this webinar, and they will take some time, visit with you, and make sure you have everything that you need.
Sure.
So we're going to start out, and we're going to have a couple questions here that have come through our forum, and also just overall questions that you'll find in Trent's ebook on 5 contract provisions. So let's get started.
Okay.
Trent?
Yep.
Why don't we start on the first one with indemnification provisions?
Sure. Well,
tell us about it.
First and foremost, Heidi, thank you and Roofers Coffee Shop for putting this together. This is great doing this live at NERCA. I always like educating. I like talking. So if you guys have questions, please feel free to ask us. But what I try to do is just focus on the things that I see day in and day out, the most key contract provisions that I know are important. And look, as lawyers, what we can do is we can take your contract and hack it up a million ways, but at the end of the day, it's about getting business, right? So what we're trying to do is just help you issue spot. From my perspective, it's a lot about education. It's a lot about helping you understand what your potential risks are, so that when you get a contract from someone else or you're looking at your own contract, you know what to expect. So one of the key things that I look for when I'm reviewing any contract is the indemnification provision. And indemnification provisions are very tricky. Let me explain in general terms what an indemnification provision is. What that says is basically that, let's say you're a subcontractor. If you, the sub, do something wrong and you agree to indemnify the contractor, then what that provision is going to say is that you, the sub, will hold the contractor harmless for any of the bad acts or omissions that you do on that job site. And that's keeping it fairly simplistic, but that's the gist of it. If you do something wrong, you own up to it, okay? Now, keep in mind, depending on what state you're in, there are different rules and statutes that govern indemnification provisions. So some of the states that have very strict indemnification rules are states like California and Delaware. There are other states that have statutes like Florida, for example, that specifically talk about what you can do in an indemnification provision and what you can't. Generally speaking, there's 2 broad categories of indemnification. Okay, there's, if I screwed something up, then I'm going to own it, and I will make that contractor or that customer whole if I mess something up. Okay, that's basic indemnification or limited indemnification. Okay, there's something that even goes beyond that, the standard form, which is what I commonly refer to as super indemnity, which says that not only will I hold you, the contractor, harmless, or you, the customer, harmless if I screw something up, but if you screw something up, contractor or customer, I'll also hold you harmless for that. So you follow me? So it's a step above that.
Wow. Okay.
And I'll keep in mind there's variations of that in between. There is, a lot of times you'll read these indemnification provisions, and a lawyer drafted it because it doesn't make any sense, right? So when you're looking at it, you want to be real careful because you'll say, hold you harmless, or agree to identify, defend, and hold harmless in whole or in part. If you see that in part language, that means that, let's say I'm a subcontractor, roofer on a job site, and my work contributed to some water damage that caused all kinds of damage to some servers or computer equipment on the interior. Well, let's say you start looking at it and you get your consultant out there and they determine that the HVAC sub is also responsible. Well, depending on how that identification provision is, even if you're partly responsible for that, the prime contractor can come back to you and say, you need to indemnify me. You need to pay me for these damages. Now, I mentioned something, and I don't want to blow by it too much. And keep in mind, this is, 10,000 foot view. If you see indemnify, defend, and hold harmless, for the purposes of this webinar, you can think of hold harmless and identification as the same thing. Defend is something that you got to watch out for, okay? What defend means is that if there's a claim like that, so let's say you're working on a roof, whether it's residential or commercial, and the owner has a claim against you for indemnification. If it also says that you'll agree to defend them, then what that means is that you have to pay for their attorney's fees, or you have to hire your own attorney to defend them. Now, nobody likes lawyers, right? So that's a big deal because attorney fees often drive some of these cases, especially the lower dollar amounts. So when you're looking at indemnification provisions, here's some practical advice for you, okay? The first thing that you want to do is you want to take a close look at it. You want to make sure that you tried to understand exactly what you're agreeing to indemnify. If it looks different, if it looks strange, more than likely it's not something that you want to just sign off on. I would recommend definitely running it by your insurance agent, because a lot of times insurance agents won't cover certain types of indemnity. And I would say insurance is a lot like your will. You never look at those policies until it's too late.
Right.
So you want to make sure that you're, especially if you're on a big job. Usually, what I try to say is you be more risk adverse the larger the job is. So if you've got $1,000 job, it's important to pay attention to it. You could potentially have some problems there. But if you're on $1 million job, then you really need to pay attention to those contract provisions. So you want to run it by your agent, and then obviously counsel. If you have any concerns about how indemnification provision is worded, it is something that I see over and over and over again. So, and representing roofers all over the U.S., one of the biggest reoccurring phone calls that I get is, we just had a water event, water leak, water intrusion on a property. Owner sent me an indemnification claim under our contract. What do I do? Okay. Wow. And that's where you really got to pay attention to it. So what you want to do, what I'm suggesting to you, is pay attention on the front end, so that when something does happen, you know what your exposure is, and you've got insurance coverage. So.
And we talk a lot about this type of practices for contractors, and really a lot of this is proactive.
Right. Absolutely.
Looking at things ahead of time before you're in that spot, before that water leak or before something happens. So even whether it's reviewing contracts you're getting or your own contracts, making sure that all that verbiage is in there to protect yourself.
Right. And keep in mind, like I said, every state has different law. So if you are, let's say you work in multiple states, we represent a lot of roofers that might be based in Georgia, but they do work in Tennessee and North Carolina. The laws are significantly different depending on which jurisdiction you're in. So you want to make sure that if you've got your go-to Idaho contract, that it's good in Wyoming, because it might not be. So you got to be very careful.
That makes a lot of sense. Okay, great. Good. And remember, as we're going through this, if you have questions, be sure to type them in, because I have to tell you a quick story on Trent. But my husband and I saw him, Tim Ellsworth, that a number of you know, we saw him speak at the Nashville, Tennessee Roofing Contractors Association. And my husband was like, how does Trent make law so interesting? I don't know either. So when he gives lawyers a bad time, we know he's not talking about himself, because he does a great job for us.
Oh, thank you.
Okay, so let's look here at contingent payment clauses. Yes. Okay, what's up with that?
So for those of you that do sub work out there, subcontract work, or for those of you that hire subcontractors, the contingent payment clause is something that you really want to pay attention to. What a contingent payment clause is commonly referred to as a pay if paid, or in some jurisdictions a pay when paid. It says that I, the contractor, don't have to pay you, the sub, until I receive payment from the owner. Okay. So again, there's a variety of case law there. Some states say okay if you've got specific language. Other states say not so much. So you start looking around. You know, Massachusetts, California have very specific rules on what you can do and what you can't do. Florida says yes, you can do it, but you've got to have magic language in there to allow you to do it. So what that magic language is, for example, in a lot of these jurisdictions, is the courts have said you must be absolutely crystal clear that you're going to do this in order for it to be enforceable. So, for example, the idea that a contractor doesn't have to pay a sub until an owner. If I said exactly that in a contract, that's probably not enforceable, at least in Florida. So you would have to say it's a condition precedent or it's conditioned upon. That's the magic language that you need. So when you see that, you know, normally if you're looking at a contract, so let's say you get a commercial contract, because this is normally where these occur. If you're getting these kinds of contracts and you're reviewing them, they're going to be in the progress payment or the final payment provisions, okay? So if you look in there, it's going to talk about conditions precedent to payment, and you might see it and you might blow right by it. It'll say receipt of payment by the owner. Okay, depending on what state you're in, it may not matter, because some states say no contingent payment clause whatsoever. But it is a big problem for subcontractors that are doing roofing, because a lot of times, you know, contractors that haven't been paid will use that as an excuse, and then the subs are left holding the bag. So be very, very careful when you're looking at that. Anytime you see that sort of flow down type provision where it's putting the burden on upstream to make sure that you're going to get paid, you want to do a couple of things. One, make sure that that contract provision is enforceable. And two, if you can, stay in the loop. Okay. Now, some contracts say you can't communicate directly with the owner if you're a sub, but I'm a big believer, you know, be a squeaky wheel. You know, it's if you have a good relationship with the owner's rep, if you're communicating with the design professionals, architects, engineers, if you're loud and everybody knows that you're out there and you're protecting your rights, you're looking for liens, you're doing all these kinds of things to protect yourself, there's a better chance that you're going to get paid. If you're quiet and just assume that everybody's going to do what they're supposed to do, then you're going to be at the last of the line.
Last line. So, and that really has to do with business overall. Right.
Absolutely.
Getting to know the owners, building those relationships, and not always that it helps on so many different planes, but obviously getting paid at the end is the most important.
Yeah.
So, what about retainage provisions?
Yeah, so retainage, a lot of times you'll see it in commercial contracts, you'll see it, I've seen a variety of different versions. The standard is 10%, so they'll withhold 10% of the contract amount through the progress payments, and then after substantial completion occurs, after punch list is completed, then they release retainage. Sometimes you'll see contract provisions that say upon 50% completion, retainage goes from 10% to 5%, which I like. You know, the idea is that everybody loves you when they sign that contract, right? You know, they're all excited about it. They're like, let's go. By the time you've gone through the end of that contract, everybody hates each other. You know, so the idea, the last payment is always the most difficult to get.
Right.
Okay, so you want to, the way that you want to structure it from an estimating standpoint is that retainage payment is gravy on top of the mashed potatoes you already got. Okay, so it should be 100% net profit. So you're not out there, you're not hoping to be able to pay, you know, your suppliers off of retainage. Now, there are certain statutes in specific states. For example, Tennessee has a very specific statute on retainage saying it can't be more than 5%. Other states have very specific statutes with regard to retainage on public projects. But generally speaking, especially if you're using like AIA contracts, standard form contracts, you tend to see the 10% retainage is sort of the standard. From a residential perspective, you know, if you're working on a large project, I'm not talking about, you know, a 1 or 2 day shingle project. I'm talking about, you know, a $100,000 clay tile project or something along those lines.
Right.
You'll see where an owner may write in the ability to withhold a certain amount of payment until punch list is completed. So it might not be called retainage, but guess what? It's retainage. It's pretty much retainage. So you know, trying to give you practical advice here. The practical advice is make sure you do what you can to get as much in the front end so that you're not waiting for that last payment, because they will find ways to back charge, find ways to set off to try to, you know, make it better for them.
Right. That makes sense. And it makes sense too, because with every project, everything is always better at the beginning.
Right.
And everybody's a little tired by the end, even on the best of jobs.
Yeah, and of course, keep in mind, I'm your pessimistic lawyer, so not all projects end up like that. My personal rule of thumb, from what I see, is that 1 out of every 20 projects, regardless of whether it's residential, commercial, industrial, you're going to have a blip.
Yeah.
Okay, that blip is a customer service issue where you got to give a discount, you got to go back and you got to do some work, you got an unhappy customer. 1 out of every 50, you're going to have a big problem. Okay, so it's just, unfortunately, it's a sign of the times. People, if you think about how technology has changed, look how we're communicating right now, right? You think about how technology has changed. If somebody wants to learn how to withhold payment from you, all they have to do is Google it and they can figure it out like that. So what I'm suggesting is, unfortunately, roofers today, they've got to be accountants, they've got to be insurance agents, they've got to be lawyers. You have to have that hat on at all time to make sure that you're protecting your business.
Well, and I think, just to that point, that's one of the great things about this industry is we have a lot of experts like Trent. We have Furman or roofing risk advisors out of Florida. We have a number of people in the coffee shop who kind of can help you with these kind of things. So as you're going through that webinar, keep that in the back of your mind that there are people out there who understand roofing who can help you. And I think that's really key as you're moving through it. The
great thing about Roofers Coffee Shop is that it's a centralized location where people that have questions, especially, I get questions all the time from roofers that are just starting out and they want to know what to do and how to do it. And I like helping people. I mean, it's, when I get those calls, I'm not sending them a bill, I really want to help them, get them in the industry. The industry is important to me, it's important to you.
Yeah.
And I think that's the great thing about Roofers Coffee Shop is it's a centralized location where you can share information, you can learn from each other, and that's the whole point of it.
Exactly. Well, a lot of these questions, we get them from the forum. Right. It's things that you all are talking about right now. So let's go on to the next one, delay clauses.
Yeah.
What's that?
So delay clauses. Now, clearly, it's real easy to say, here's how much I'm owed on a project. Okay, let's say you've got a residential project that you're doing, a shingle project, it's $12,000 shingle job. Okay, it's real easy to say, here's how much it costs, here's my profit, here's gross net, here's what I'm owed. But let's throw some what ifs in the mix. Okay, let's say the owner prevents you from accessing the job. Let's say the owner, you're doing a job in Alabama, and the owner moves up to New Jersey, and you can't get access. You've already got the materials out there, and there's some issues with regard to permitting or whatever it might be that you need to get their attention, and you're not getting it. Okay, that's causing you delays. And you might have equipment out there. You might have allocated certain manpower for that job. It's a smaller job, so it's not likely. But on the bigger jobs, it's definitely an issue. So you want to think carefully about what your delay damages are. Okay, and we've prosecuted delay damage claims in the 10 million plus amount. Because if you think about it, if you're on a large job, you've got a lot of equipment that you're running.
That's true, yeah.
You've allocated a significant number of crew members to a specific job. If they all of a sudden start delaying or improperly suspending it, or let's say another trade is prohibiting you from being able to complete that work, and you run into, depending on where you're doing work, a rainy season, that can cause a traumatic impact on that, not just that job, but your business as a whole. So what I'm suggesting is that if you get a contract and there's a delay provision in there, you want to read it very carefully, okay? Because there's a provision that's commonly referred to as a no damages for delay clause. What that is it says that if you are delayed, you are not entitled to damages. You might be entitled to additional time. So let's say you've got 180 days to complete a project. If you don't complete that project in 180 days, then for every day after that, you owe liquidated damages of $100 a day. So you might be able to get additional time on that, but they're not going to cover your cost. Okay. So if you see that, you really got to pay attention to it, because you've got to make a decision as a business owner. And look, I say this many times everywhere I speak. If you guys did everything that I told you to do, that your accountant told you to do, your insurance company told you to do, you'd be out of business. So I recognize that. What I'm trying to do is you've got to put on your business hat, and you got to say, do I know this customer? Is this going to be a situation where I could face a significant amount of delays? Another great example is condo work. Condo work is tough. You sign a contract with one board that loves you on day one. You get ready to do the work 3 months later, they got a new board, they hate you, and they want their uncle to do it. And then all of a sudden you got a problem. So when you're looking at delay clauses, you want to see that. You want to see, what is the claims process? Am I entitled to damages? Am I entitled to time? And how does that work? One of the biggest things that I think roofers, when they get the complex contracts that they need to focus on, is the notice provisions. And we'll talk a little bit about that, but they want to have whoever their project admin staff is, whoever's out there in the field, to go through that. And if it says, give me notice in 10 days via telegram, then guess what? That's exactly what you got to do. So you want somebody, whoever's following that project, to make sure that they're, crossing the T's and dotting the I's. And I'm a big believer, if it's good for you, you put it in writing, and if it's bad for you, you pick up the phone.
Pick up the phone, right, and talk to them. Exactly. And it really seems like this all comes back to really understanding your customers and understanding having the project, your project managers really understanding the project and going through that contract to understand. Your
project manager or superintendent, foreman, crew leader, whoever you have out there running that job, they've got to understand potential risk and liability. Now, look, I don't expect them to be lawyers,
right?
But they got to at least be able to issue spot and say, this is something I need to call the home office with. Exactly. And if they do that, then that's going to help prevent a lot. It's the people out there in the field that can make or break you.
And being careful, like you said, about what you put in writing and what you don't. Sometimes it's just better to pick up the phone and have those conversations. Right. I've learned that.
Yeah, absolutely.
Over the days.
Oh, and one last thing on that. Text messages are discoverable.
Oh, so, right.
I've had, we had an arbitration 2 or 3 months ago, and in arbitration, you don't get a lot of chance to do the kind of discovery that you would do in a case. So when I'm in a case, I get to ask for documents, get to ask questions. I'd sit you down, I'd have you under oath, I'd depose you. Arbitration, you don't really necessarily get to do all that all the time. So a lot of times you're walking in and you have maybe 75% of what you know, and then there's always sort of the surprise element. Well, one of the surprise elements in this case was that the roofer happened to have a few conversations about midnight on a Saturday via text message.
Not good.
Not good. I mean, we still want a case, but those are the kinds of things where you don't want those coming out, because there's some salty language in there and it doesn't look good in front of the arbitrator. So.
Anything in writing, they can track. They can track as you go. And, talking about things in writing, we deal with warranties in this industry all the time. Everything that's going on. How do the contractors incorporate them? How do they protect themselves?
Warranties are one of the things that I'm flying on the plane to come to NERCA, like a few hours ago, just a few hours ago. The entire time I'm working on a warranty issue for a contractor, because here, I'll give you some great examples. First and foremost, if you're a residential contractor and you're saying, I'm going to give you a 1-year warranty or a 5-year warranty or a 10-year warranty, whatever the warranty is, do you have a written limited workmanship warranty? I can't tell you how many times I've seen that where they say 1-year warranty, but I know what that means. Does the homeowner know what that means? Does it mean you cover storm damage? I don't know. So the point of having anything in writing is certainty, is to get rid of that ambiguity. So if something comes up, you got it. Now, here's one of the issues that I've seen over and over again. Okay, manufacturer warranties, and there are generally 2 types of manufacturer warranties, and I'm putting them in general categories. Yeah. There's the general material warranty, where all it covers is the material, and there's the equivalent of the NDL and the no dollar limit warranties, and it's the super warranty, where they're going to cover some aspect of workmanship after a certain number of years, as well as the material warranty. The latter has true value. Okay, right. The former isn't really worth much anything. So the issue that you have to often face is when it comes to a warranty problem. Let's say you have what you believe is a material failure, and you go to submit that to the manufacturer. What the manufacturer's tech rep is going to do is they're going to go out there and they're going to look at it, and they're going to see if it was a proper installation.
Right.
Okay. If let's say, I ran into an issue where there was incompatible underlayment it was product A underlayment and product B top. And what happened there is both of them said, we're not going to warrant either one of these things because it wasn't our product.
It's not in the system.
Right. So you want to be real careful about how you deal with that. One of the biggest things that I've seen is when you're selling a roof, okay, when you got your salespeople out there, regardless of if it's commercial or residential, make sure that your manufacturer can give you the warranty you told you were going to give to your customer. Because if you can't give that, and we had this happen with a condo, the condo comes back and they say, look, this isn't exactly what you promised. You promised X, you gave us X minus 10. close, but not exactly what we promised. So that's a dispute, okay? And that's something ultimately we're able to resolve it, but it costs the roofer some money.
Right.
So you want to be really, really careful about what you promise and how you promise it. The best thing that you can do is be very specific on your proposals. You know, talk about exactly what the warranty is. Now, when do you give out warranties? Now, normally I have in my contract that if you don't receive payment, you're not going to get your warranty. Okay. Once you issue payment, you'll get the warranty. But let me give you some practical pointers. Okay. So you got a residential job and it's, you know, $15,000 shingle roof. You get paid, I don't know, $7,500 of it. And they're not paying, they're slow paying you the rest. They're not paying it. They're hemming and hawing. But then you get a phone call saying, I got a leak. Can you come out and fix it? Okay. Now the general tendency, if you're like me, the general tendency is, you know, I'm not coming out, you haven't paid me. You know, the problem with that is what's going to happen is they're going to have water intrusion. They're going to come after you. The insurance, they're going to either, if they submit it to their homeowner's insurance, the homeowner's insurance is going to file a claim against your insurance company. If they go directly against your insurance company, it's going to increase your premiums. So as much as it hurts, I'm a big advocate in going out there and seeing what you can do to remedy the issue, because what it does is it takes those issues off the table. Okay, it gets rid of them so you can focus on payment. And that's tough. I have to fight a lot of my customers all the time on that issue, but it's because I've been there, done that. Right. I know what happens when you let those things fester.
Right. So. There's nothing worse than having that kind of those issues and then something on top of it, and then you're dealing with manufacturers and everything else is coming into it. I've worked for several different manufacturers, and warranties are always a big deal. And so what you said about being sure you've read the warranty, you understand how it has to be installed, what type of products, if it's a full system, all of those things really do make a big difference when you're selling it.
Yeah, and absolutely. And you know, when I run into issues with enforcement of warranties, a lot of times what I'm able to do is obtain an engineer's opinion as to the viability of that system, and then have the roofer increase the workmanship warranty to account for some stuff. There's a lot of horse trading that sort of goes on as far as, you know, we'll give you a little bit here, a little bit there, but a lot of times what I've done is I've used that engineer stamp to basically say the system is as it's supposed to be.
Okay.
Sometimes they're attacking it based on uplift or things of that nature, tech specs.
Right. So. A lot of that going on in Florida after the hurricanes.
Yep, Florida, Texas. Yep.
Yeah. Speaking of everything that's going on, pre-existing conditions.
Sure. So, you know, keep in mind as roofers, you're not called out unless you're not called out unless there's a leak. Okay, there's the occasional proactive customer, but they're few and far between. So that means that there's already pre-existing conditions in place. Now, contracts are there to protect you, right? They're there to provide you with stuff that you can defend yourself, but also to help you prosecute your claims. But I also think that there's an educational component to contracts, okay? Because most customers aren't legally sophisticated. And a lot of times what you can do is you can use contract provisions to help educate your customer. So one of those things I like to include in my contracts is a pre-existing conditions clause. Now, you're probably saying to yourself, Trent, I love you so far, but why would you have a pre-existing conditions clause in there? Because pre-existing conditions, I would never be liable for that, right? They're pre-existing. Yes, that's true. But if you have something in there, it makes it a lot easier to explain to the owner. So let me tell you what I'm talking about. Okay, you go out to a job, you know that the roof's been leaking for a while. Okay, you see the wet ceiling tiles, you see all the telltale signs. You already know that there's going to be some significant deck replacement. So you go in there, the homeowner's showing you around. They actually give you access to the attic, which is a rarity. But you go in there and you see all that. Now, wouldn't it be great? You know, we live in an age where I've got my phone over here. I can do all kinds of stuff. I can video. You name it. I got it. Wouldn't it be great if your salesperson or whoever was in there taking photos of all those pre-existing conditions? Okay, so let's say they did that. Then you get to work. 3 days later, you submit the final invoice, and they say, well, the roof leaked, you know, while you were doing work. You need to pay me for this. Okay, what you can do with a contract provision, the pre-existing conditions clause, what is that? Okay, basically it just says, I, the contractor, disclaim any liability for the following pre-existing conditions. You know, and I'm giving you the simple version, but, you know, mold, mildew, dry rot, termites, any of the kind of things that you normally inspect. So when you get that disgruntled homeowner or commercial owner or even contractor, that come to you and you say, look, I'm just not going to pay you because of this. You can say, well, remember this video that we took on this date? And then, you know, I appreciate you as a customer, but here's a clause here. I know you read this because you initialed this terms and conditions page. You know, let us know what we have to do to make you happy, but, you know, this isn't something that we did. And that's it. Now, your contract is always your last line of defense. It's the trench that you fall back into. You know, you guys wouldn't be on this call right now if you didn't have good customer service, right? That's how we all stay in business. So Heidi does her thing, I do my thing, you guys do your thing. Customer service is what keeps the customers coming and keeps them happy. So a lot of times you can resolve a lot of the issues with just good customer service. But when that fails, it's useful to have a contract to fall back on.
Yes.
And you can also tie in some of this educational type provisions, you know, to assist in helping the homeowner understand how you're getting from point A to point B.
Well, and I love that, actually taking pictures, video while you're on that sales call and show it, saying, hey, I see damage here already. We're going to have to work through this, and say, oh, and by the way, you'll notice this is not covered, so that they know ahead of time, because there's nothing worse than getting that call and saying, oh, there's dry rot here and you didn't do anything.
Yeah, this is, and Heidi just brought up a great point. So clearly, I know you guys don't get access to attics all the time. Doesn't happen. You don't get access to the interior of the house all the time. When you do, take advantage of it. Another good example, driveway cracks. Okay, how many of you guys have, and for any of you that are doing residential, have you ever heard that I'm not gonna pay because I got a driveway crack? Okay, I know you have, because I get a lot of those phone calls. So that's another great thing. Before you get the supplier out there to rooftop those materials, before you bring your trucks out there, take some photos of the driveway, you know. And a lot of times what you can do is you can say, look, there's an added provision that I add on. It's another whole page that says, I can't, you know, you recognize we got heavy trucks that might cause cracks to your driveway. You're going to disclaim, waive any liability related to that, release me from that liability. I can give you another option where I can hand load it, but here's the cost for that.
Oh, that makes sense. Yeah.
So what I'm saying, what I'm trying to say here is you manage the customer's expectations, right? If you manage the customer's expectations, then a lot of these issues aren't going to come up. You know, they'll understand where you're coming from, and you're just taking those arguments away from them. So when the time comes for payment, you know you're going to be good.
Well, and from a sales perspective, you have a happy customer because everything's honest and upfront, and it makes sense. I love that, taking pictures of the driveway ahead of time. That's great. Yeah. Great tip.
Yep.
So, okay, on venue provisions.
Sure. So venue provisions, no matter what state you're in, venue provisions is a good thing to have in your contract. And what that says is that if you're in a dispute that arises or relates to the contract, then what's going to happen is you're going to go fight that in this court. Okay, you'll set the county. So typical venue provision will be, venue for any dispute arising out of or relating to this agreement shall be Monroe County, you know, Idaho, shall be, you know, Dade County, Florida, shall be whatever it is. And what you want to do is you want to think carefully about those venue provisions. So let's say you're a subcontractor, or you're receiving a contract from an upstream customer. You want to look at their venue provisions very carefully. Now, if you're in a large city, let's say you're in Denver, Phoenix, or Los Angeles, it's not going to matter too much. If you are in a smaller county or a smaller city, it might make a difference because you're going to know a lot of the people there. Your home office will be located there. It's going to be cheaper for you to litigate, you know. And a lot of this is what I always try to do up front is give you the cost benefit analysis. Just say, look, here's where we got to go. Because what, you know, I always say the day of the principal client is over. That ended in 08 and 09.
Yeah.
You know, what it has to be about now is about business. It's got to be about making sure that you're maximizing the dollars that you're going to get in your pocket. So you need to think about venue provision. Where are you going to fight your battle? If you don't have that in your proposal, you could have a problem, especially if you're going outside of your general county or outside of your state. So it can make a big difference. The other thing that you want to think about is if you're doing work in multiple states, and there's very specific rules on this, but I'm just giving you sort of surface level, is think about the law that applies, okay? So a lot of times, you know, I'm reviewing roofing contracts that have come from prime contractors that are out of state, and they're doing a job in Florida, and we'll say New York law applies.
That's not,
No, you know, we're striking that immediately. It's law of where the project's located. So that can make a big difference because there's a vast difference in law depending on which state you're in.
Right. And a lot of our contractors are traveling. They're traveling for across the country and definitely across the states. So great thing. Even in my own contract, in my business, I have venue provisions. You just don't want to have to go out of your own area.
One of those things, there's so much boilerplate and contracts. A lot of times you just blow by it and you don't think anything of it. But that's one where you can actually use it to your advantage.
Right. That's really good. Oops. Okay. Make sure we got here. Homeowner defects.
Yep. All right. So I get this question a lot. Does a homeowner have to notify me of a problem? Better yet, does an owner or a customer have to notify me of a problem? The answer is yes and no. So I'm going to try not to give you a lawyer answer. Some states have very specific statutes on what homeowners or commercial owners must do before they file suit for a construction defect. So to give you an example, Florida has Chapter 558, which says that you've got to give notice within 60 days, generally speaking, before you file suit on a construction defect and give that person an opportunity to cure it. Okay. What I like to do is I like to contractually require it. I think I'm a big believer in notice. You can't fix something if you don't know about it.
Right.
So in roofing, unlike a lot of other trades, the biggest issue is timing. You need to know about a water leak as quickly as possible. Now, let me back up. Standard notice provision, what does it say? It says, customer shall provide written notice of any defect or claim it has within 48 hours of occurrence. If it fails to provide this written notice, then it waives any damages or claims it may have relating to that. Generally speaking, that's the idea of it. So, you're probably sitting there and you're saying, well, Trent, why not just make it an hour's notice? Because it's not reasonable. You've got to give at least enough time for people to be able to respond to you. And you want to be very specific about how you get notice. So a lot of times, I'd say you want the notice as quick as possible. Say email at this address or written notice sent here, or you want to give them several different options. You want to make it easy for you to get notice because you want to be out there so you can prevent it. An ounce of prevention is worth a pound of cure. So I like having those kinds of provisions in there because regardless, doesn't matter what state you're in the United States, doesn't matter whether they got, statutes on it or not, have it in your contract because, again, it protects you and it provides education. We've defeated a lot of claims because people have not given the proper notice. And it's pretty easy, when I'm in front of a judge or when I'm in front of an arbitrator, all I have to do on this kind of claim is just say, I show them the evidence. This is when the claim was submitted. This is when the claim occurred. Here's the contract provision. There you go. That's it. And I'm simplifying things, but that's, it's fairly easy from a factual standpoint to show when something happened and when notice was given. So definitely recommend that you at least include a notice provision in there because what it's going to do is assist you in these types of things.
And it kind of goes back to what we started with at the beginning is a lot of this contract, really being smart about contracts is proactive.
Yeah, absolutely.
Being ahead of it, understanding so that when you finally get into that customer that's not so happy, you've got everything in line. And so really taking the time before you need to really makes a difference in having everything put together, not just from contracts, but safety, OSHA, the whole 9 yards. Just make sure you're in place.
Something I should probably mention here, and I think one of our questions that I'd seen that kind of dealt with this issue is a couple of different things. One was negotiating capability. A lot of times if you're getting a contract upstream, I hear it all the time. It's like, they're not going to accept any markups. And I'm like, fine. Okay, well, at least understand what your risks are. And what I like to do is, look, like I said, I could completely rewrite a contract. That's not going to do anybody good. What I'm focusing on are the 3 or 4 things that are potential business owners. I'm looking for a lot of the stuff that we talked about: identification, pay if paid, those kinds of things that really, no damages for delay, those kinds of things that will affect your ability to get paid on a project. So if you have to focus on stuff, focus on certain things. And a lot of times you don't know what you can get until you ask.
Right.
You got to know who you're dealing with, and at a minimum, understand your risk and liability as it relates to that. The other thing that I get asked a lot is standard residential roofing contract is usually proposal on the front page, terms and conditions on the back.
Right.
You know, homeowners don't want a lot of mumbo jumbo. They don't want a 50-page contract. They're going to go on to the next person.
Yeah.
So a lot of times I get asked, you know, Trent, I love you to death, but there's a lot of really, you know, great provisions for me in this contract. Is it going to turn off the homeowner? Okay, that's a valid question, right? You know, business always comes first. So what I say in response to that is look, you know, we've done hundreds and hundreds and hundreds of contracts. I have contractors that occasionally come back to me and say, this homeowner has this issue with this provision. And my response is very simple: negotiate it. You know, if the job is good enough, get rid of it, you know, but not putting that stuff in there, not even trying to get it in there. I wouldn't do that. You know, I think that the majority of homeowners out there are price driven, and I think they're looking at price and scope, and the terms are usually an afterthought. I mean, I know, you know, I shouldn't say this, but I was just reviewing a lease, and we're getting ready to. I needed more space at my headquarters. We're renewing a lease, and really all I looked at was price and square footage and that kind of stuff. And then I had, you know, another person in my office look at the details. Yeah, look at the terms and conditions, because from a business standpoint, all I care about, you know, is how much it's going to cost me and that kind of stuff, you know. But whether it's you or it's somebody in your office, you want to look at those terms and conditions and make sure you're comfortable with it. If you're reviewing contracts, if you got customers complaining about it, then feel free to negotiate. You know, it's you never know until you ask, and I would much rather have that stuff in there.
Yeah.
You know,
it's a combination of proactiveness and knowing your customer, knowing the markets, knowing where you're at.
Right.
It's putting it all together.
Yeah, absolutely.
Yeah. So we had a question come across from Patty, and she wrote, suppose you received a subcontract from a general contractor owner, and it is a very one-sided contract with many pitfalls throughout, and you have negotiated some things, but others that they will not budge on. What is your obligation when you have not signed anything and decide you want to give this contract back and not sign it?
Okay.
Submitted by Patty. That's a long question.
No, that's a good question. Thank you, Patty, for the question. The answer is you probably don't have any obligation. So let me go through that, because this is, you know, when I give contract seminars, I think I did this at a diary 2 or 3 years ago. I was talking about contract formation, and as soon as I say contract formation, you know, I could see and I'm like, no, stay with me, because this is important. So when you're dealing with a contract, a lot of times you need to know who's on first, you know, how you're negotiating and what you're doing. So if you get a contract, so in your example, Patty, you said you got a contract from an owner. It was one-sided. You marked it up, you sent it back. So is that an acceptance of that offer? No, it's a counteroffer. Okay, so you made a counteroffer to that owner. Now, if that owner, you know, initials it, sends it back, then they've accepted your counteroffer. If they say, no, we're not going to take that, you're good. If you go out and you start doing work without getting that confirmation, you got a problem. Okay, because that shows that you're tacitly agreeing to some form of contract. There might be an issue with regard to mutuality of terms and who agreed to what, but at a minimum, you're going to be bound at that point because there's some performance. So that's a little bit more dicey. What I recommend, and it used to be when you know, 20 years ago, it was fax cover sheets. There's no fax cover sheets anymore. So what I recommend is that when you're sending stuff back and forth via email, you got to make sure that you close those loops. Those people that are in your office, whether it's you or somebody else, close those loops and have everything initialed, have everything signed. Do it at the front end, because there's nothing worse. You know, I had a roofer call me recently. Big blow up with a subcontractor. Could not find a signed subcontract, and it was a subcontract I had prepared that would have absolutely helped them. And so we came up with a way to get the sub to sign that contract and get it back. But the key is before you know, if you're in a jurisdiction that requires permits, or before you start work, get all that documentation signed. You know, don't leave it. Don't be in a situation like Patty where you're scratching your head going, do I have a contract or I don't have a contract? So.
You know, that's really good advice too, because you do all this work, get all these contracts together. You got to make sure all the processes are in place with your employees and within the company, that all the I's are getting dotted and the T's are getting crossed.
And what's interesting is, you know, so Heidi and I are both part of a roofing technology think tank, and technology is transforming the industry. It's one of the reasons I wanted to get involved. And what's really interesting now is that there's so many roofers out there that are utilizing technology to make sure that stuff like this, contract negotiation, you know, they'll send out proposals, they're e-signed, they come back. If they don't sign them, then there's automatic email reminders that go out. And what it's doing is it's taking a lot of that human error, that human risk, and removing it. And it's automating some stuff. So it might be something worth looking into down the road.
It makes it part of the job process. The job sometimes can't even move on without all that being done.
Yeah.
It's great technology.
Oh, yeah.
Yeah. So, Karen, do you want to join us for a minute? Do we have any additional questions? I know we're right on time.
We are. Yeah, we're doing well. Hi, everyone. I do have a question that was submitted by Robert. It's a long one, so bear with me. Trent, he asks if you would touch on hold harmless agreements between contractors, owners, consultants that address fees for litigation, mediation, and arbitration, if it comes to that, wherein the owner is expected to pay the fees if the consultant is drawn into a dispute, or if the contractor is drawn in when they're under a subcontract with a general contractor.
Okay. So we talked a little bit about, duty to defend, and this is kind of what this is hitting on. The duty to defend oftentimes is buried within the indemnification provision. And what that says is that if you end up in a dispute, depending on which direction you're going, you may be liable for the other party's attorney's fees. And like I said, I've said it at least twice today, nobody likes lawyers. So the attorney's fees can be very expensive, so you really want to pay attention to that, because it can sometimes be more than the amount of controversy. When you're a consultant, you want to be, generally the contractual framework is you've got, I'm trying to figure out where my hands are, owner, prime, subcontractor, right? Okay, then you've got owner, consultant out to the side. They usually have a separate contract. Okay, when you have that, the same rationale applies. So you want to look in your contract and you want to figure out who's absorbing the risk, where is the fees sharing going on, who is liable and who is not liable. Again, a lot of it deals with your negotiating capability. If you have the capability to shift that burden upstream, do it. A great example is a lot of times, even in commercial work, if you're sometimes a commercial owner will ask you for your contract. That's awesome, right?
Yeah.
So you should have fair provisions in there, but you should also have a lot of provisions that serve you, because it's your contract. So don't shoot yourself in the foot by putting a lot of one-sided provisions in favor of the owner in there. So my recommendation is look real closely at that duty to defend language, figure out where the fees are pointing, and then determine whether or not that's something that you want to modify based on where you are in the contract. Especially if you're a consultant, or if we have any design professionals that are on here, you guys have a lot of liability. So what you want to make sure is that you're insulating yourself to the best of your ability if you're negotiating with the owner directly.
That's good.
Okay, thanks. Yeah, I don't have any others. That's it.
Okay. Well, I just want to point out that Trent has a new book. We talked a lot about legal today and about obviously contracts, but Cotney Construction Law is also well known for their OSHA defense across the country. Maybe just real quick, I know we have your book up here and it's available for folks to learn quite a bit. Can you just say a little bit about that?
Sure. So we fight for the industry is what we do. My grandfather was a roofer. I grew up in construction, and all the lawyers that I employ that do construction, we all worked construction prior to being lawyers. So the best compliment that anybody can ever give me is that I'm not like most lawyers. So we do OSHA defense, and I've done it for 20 years now. We do it all over the United States. It's something that we're very passionate about. We believe in making sure that roofers know their rights. Obviously, the most important thing for everybody on this call is safety. We are huge advocates and proponents of safety. But at the same time, it's important to understand what your rights are during an OSHA inspection and an OSHA citation process. So we came up with a book. The first version came out 2 or 3 years ago. We just updated it. There's not a lot of legalese in it. It's designed for roofers. I figured if I'm going to do something, then it better be something that people are going to read. So what I can do as part of this Roofer's Coffee Shop is if there's any listeners that want a free copy of the book, if they just, how can they get it?
They can get it, well, right now, it's on our promo and rebates
Yeah.
page, where you can just go in there, fill out the form, and you get a free book.
Yeah, I'll send you a free book.
And we'll get you a free book. If for some reason you can't find it on there, you have any problems, you can just, Trent's ads right there on the front of the home page. So you can click that, ask for a free book. You can email myself, Heidi, or we have all of your information here too, Trent, on screen.
Yeah, happy to get it to you.
A lot of easy ways to get not only this book, but also your ebook on contract provisions, and a lot of the different things that you're doing in the industry is all in the coffee shop and on your new website that's coming out pretty soon too.
Yep.
So there's a lot of great stuff here. I really, I would like to talk about possibly maybe in the fall having you back to talk a little bit about ocean defense, and we
I'd love
can
to. Yeah.
really talk about what to do. It's kind of a good winter topic.
Yeah,
Kind of
it's something I'm real passionate about.
Yeah.
So happy to do
It'd
it.
be good. So thank you so much for being on with us today. Our next webinar, we're going to take a little bit of a break. And so our next webinar will be the first part of May. And we are going to have special guests Nearmap talking about their aerial imagery. We're really excited about that. They're part of the RT3 group, the roofing technology, and they're bringing some really amazing technology for your business. So they'll be here and you'll be watching for notices on that. This webinar is being recorded and will be available on our webinar page, and you can download that and watch it anytime you want. So thank you, Trent.
Yeah, my pleasure. Thank you.
And we'll see you all again soon. Thanks for joining us today.
Thanks, guys.
I might have to cut off that last part. Okay. There we go.
Done?
Now in the whole thing, you are clear.
Cool.
If I can see this. Set webinar by all.
So